second day of our conference. My name is Joachim Savelsberg. I'm on the sociology faculty here at the University of Minnesota. I did not have to travel far, but then you have a conflict between your ordinary work and family life and the professional involvement in the conference. The panel this morning is about law and memory in transition. It's a topic that is very close to my heart and to my mind. And I want to make just some very brief introductory comments, and I will also be brief in my responses to the papers because I would like there to be sufficient time for a conversation with the audience. One thing I would like to comment on is that on this panel of 4 people, 3 out of the 4 were together on the panel a little more than 1 year ago in Warsaw, a conference entitled Legal Frames of Memory. It's a regular conference, but 3 of us were there. And it was a very, for me as a newcomer to Warsaw, an impressive experience, because it was not just an intellectual engagement with the issues of memory and law. It was almost all participants were East Central Europeans and East Europeans. It was a struggling with the memory and the transitions that people had experienced in their own countries. So there was an intensity to this that was stunning to me, that I didn't know from American academic conferences. The second thing that surprised me was enormous skepticism toward transitional justice that was articulated by so many East European scholars who were present at the conference. I'm not just surprised because I know the drawbacks of transitional justice. I know that justice can be instrumentalized. I know that there are competing narratives to justice. I know that there is a particular institutional logic to especially criminal trials if they become a tool in transitional justice situations. There is, in the institutional logic of law, a strong emphasis on the binary logic between guilty and not guilty. There are limits to the evidentiary criteria that are being applied in a criminal trial. And there is a focus on individuals that brackets larger cultural patterns and social structures that a criminal trial cannot account for. So I'm, in this context, Bernhard Giesen, a German cultural sociologist, talks about decoupling. We find some members of our society guilty, and the others don't have to worry about their past any longer. So I found this skepticism for transitional justice. It made sense to me, but it was also surprising to me. It was surprising because it is in contradiction to the early hopes invested in criminal law after totalitarian regimes and after grave human rights violations. There are the famous words by President Roosevelt and Justice Jackson, who, when preparing for Nuremberg, said we need to document everything under oath, with witnesses under oath, with all the written documents, so posterity can never doubt incredible things that were committed. There was a lot of hope, and this hope is reinforced by sociological ideas, Emil Durkheim, Maurice Alpfax, who invest a lot of hope in the ritual power of criminal trials. And then it is surprising, in light of recent scholarship, I think of the work of John Hagen, Justice in the Balkans, his assessment of the ICTY, I think of the work of our former colleague Catherine Sicking and her Justice Cascade, who looks at transitional justice situations all over the world and who assesses the impact. And she finds that there is at least a modest impact. It's not just retribution and possibly deterrence, but a modest impact on the writing of history, a modest impact on an improved democracy and human rights record in countries that underwent transitional justice, especially where criminal trials were coupled with truth commissions. So today we will hear more about transitional justice, and we'll see if the pessimistic or the optimistic picture will get support. Our first speaker is Ryan Moltz. Ryan Moltz earned his PhD in sociology in our department here at Minnesota, wrote an impressive doctoral dissertation on the issue of lustration in the former Yugoslavia, and this is what he will be talking about. He today works for a research branch of the legislative body of the state of Minnesota. And without further ado, Ryan, please let us hear your story. Is it hard to hear me?
Pardon?
Is it hard to hear?
No, it's not, and we're a small group, but
Good.
I'm conscious of hearing, so makes it easier.
Can you hear me? Am I shouting? Okay, so today I'm going to talk about lustration, which is a word that I don't think has come up yet so far in our discussion, but which is a little bit surprising because it is the primary mechanism of transitional justice that's been used in the post-communist states, with the exception of the trials in the former Yugoslavia. So today I'm going to talk about what lustration is and its importance to this region. I'm going to, and then I'm going to compare the divergent outcomes that have happened with attempts to implement lustration specifically in 3 former Yugoslav republics, Croatia, Serbia, and Macedonia. And I'm going to discuss why I picked those cases and my methods as well. So first, what is lustration? It's, in English at least, it's a kind of funny word that you don't hear very often. It comes from Latin, has a root that means purification. So in this case, what people are talking about purifying is the state, purifying the state by cleansing it of potentially bad actors. So it's a vetting process, and usually in the post-communist states, what happens is people who are determined to have been either former members of the secret police or their informants get disqualified from holding public office, certain public offices, for some period of time, usually a range of 5 to 15 years, although in Czech Republic, I believe the ban is indefinite. So the details of these laws vary from country to country in terms of who's subject to them, what were the potential offenses that would make someone, that would disqualify someone from office, which offices you would get banned from, and like I said, how long it takes. This type of procedure is not unique to the post-communist states. There are varieties of vetting mechanisms that have been used in other transitional countries. Most recently, these types of laws have been adopted in the North African transitional countries, Egypt, Libya, and I believe Tunisia as well. Don't know if they'll ever be enforced, but and also they've been used in some other places too, Greece after the military junta, for example. Lustration is given it's kind of amorphous in terms of what people expect it to accomplish. There are a lot of goals that people have for it. One is accountability for human rights violations. Certainly the secret police engaged in a lot of those, surveillance, blackmail, etc., political imprisonment, coercing testimony from people, and sometimes things like assassinations too. It's also given the goal by other people. They say that lustration is necessary to stabilize new democracies. So the idea is you have a new democracy, it's fragile, you want to prevent the old regime from returning to power. How do you do that? You ban them from the ability to hold office. It's also purported to increase trust in government. So if you have out with the old and in with the new. It's people you can trust. And then another view of it is that really lustration is done to smear and malign potential political opponents and get them out of the way. I think there's some evidence that that last point happens quite a bit. How does it work? I'll give you the example of Macedonia, which is the country that I know best that has a functioning lustration system. So what happens is if you want to seek office, so when I say public offices, I'm talking about things like member of parliament, sometimes it's prosecutors. In Macedonia, they've actually extended it to include other fields to journalists, people who head up NGOs, etc. But people who want to hold these covered offices and the current office holders must file an affidavit with this commission that was set up by the legislature called the Data Verification Commission, and you swear that you were not a collaborator with the Yugoslav secret police, the UDBA, and that you weren't a member, weren't an informant. There's an 11-person commission that goes through the available secret police files that they have, and they use those files to determine what level of collaboration you had with the regime, if any. Then the commission issues its findings and posts relevant, what they call evidence of collaboration on their website. And I'll come back to the point about why I put evidence in scare quotes. But for now, I will say I'm not here to talk about whether lustration is good or bad or whether it's ought to be done. I'm not making a normative statement about that. But I am saying that it exists and removal from office does happen. This particular person is just one example, but he was a high-ranking official. He was the president of the Constitutional Court, Trendafil Ivanovsky. He was declared lustration positive, meaning he had been a collaborator, they say, in 2010, and he was removed from office. So this would be like in the United States if Chief Justice John Roberts of the Supreme Court was found to have been complicit in like the CIA torture program or something and then was removed from office. So it was a high-profile incident. Lustration is, it has some similarities but also important differences from other transitional justice mechanisms. One, in the presentations yesterday we heard about the individual criminal accountability model. Lustration is not a criminal punishment, it's a sanction, but it, if you're found to have been a collaborator, you don't go to prison or anything. But it's also not an individual punishment. It collectivizes punishment in a way that trials don't. And what I mean by that is that it is, people are sanctioned on the basis of membership in a group, regardless of what their individual actions may or may not have been as part of that group. There's a case that went to the European Court of Human Rights, I believe from Latvia, where a man who had been a member of the KGB was lustrated on that basis. And he didn't deny that he had been in the KGB, but what it turned out was he had actually just served as a border guard. He wasn't someone who was a spy or anything. And the European Court of Human Rights sided with him and said, you have to look actually at what the person did in terms of their actions, not just the fact that you were in the KGB shouldn't be a reason alone to ban you from public office. It's potentially different from other, lustration is potentially different from other mechanisms in that both perpetrators and victims are sanctioned. And by that I'm talking about it's not only the secret police members themselves, but also the collaborators. And this I find to be very problematic because there's not attention always given to why someone was a collaborator, what duress they were put under, what threats were made to them, why they were giving evidence about their friends or family members. And yet they are subject to these laws too, at least in some countries. And a third way that lustration is different from these other mechanisms is that the international community is generally unsupportive of lustration policies. Yesterday we heard that maybe there would be no prosecutions or no without the international community in Yugoslavia, and I think that the same can't be said of lustration. Because there's no consensus internationally that it is a thing that ought to be done. And just to give you some examples of that, there have been several cases, I just mentioned one that have been brought before the European Court of Human Rights, and also to the International Labor Organization, who have bodies that issue advisory opinions and rulings about violations of rights, of treaties that countries have ratified. Cynthia Horan has a paper where she shows that every case that's been brought before these bodies that has dealt with lustration, they have sided in favor of the lustrated person, saying that their rights were wrong. They have stopped, these bodies have stopped short of saying lustration itself is problematic, but they, in practice, they say it hasn't been applied fairly, and it violates a number of rights they have found, including basically a lot of due process rights, also employment non-discrimination. As another example, the organization that is now known as Human Rights Watch, when Czechoslovakia passed their lustration law in 1991, they issued a report and a statement that said the Czechoslovakian government and the Constitutional Court should repeal the lustration law. That's pretty overt opposition to it. And more recently, the Venice Commission amicus brief on the Macedonian lustration law has said that, because I'll get to this in a minute, but Macedonia first adopted their law in 2008. So the Commission said, introducing lustration measures a very long time after the beginning of the democratization process risks raising doubts as to their actual goals. Revenge should not prevail over the protection of democracy. So again, no international consensus that this ought to be done, yet it does. And the literature on lustration has tended to focus, I would say, mostly on a handful of cases. Czechoslovakia especially, and the Czech Republic, Poland, sometimes Germany. But as you can see from this slide, lustration has been either adopted or at least considered in many countries. So what I've shown here is the first column, and it goes to the top of the second column, is the timing of the first lustration law that a country adopted. And actually, if a country has one lustration law, they're very likely to end up having a second one, because they often get either the scope gets expanded by subsequent legislation or contracted, or there might be a court ruling that strikes down part of a law, so they have to rewrite it. Then the next set of countries where it says first bill, so these are countries where at least a bill was put forth in Parliament, but they weren't adopted. And so this ranges, there's a variety of extreme situations with this column. I mean, some countries like Croatia, the lustration bill was never heard, there was no reading of it, and it was never voted on, versus Armenia, which actually came really close to adopting a law. And then the last set of countries are countries that have not adopted it at all, or not even proposed it, as far as I could tell. It's mostly former Soviet republics, plus Kosovo. So, with that background, that brings me to my research, which, as I said, I believe the literature heretofore has focused mostly on just a few cases and ignored others. So negative cases have largely been ignored. Nadya has actually a paper from 2004 that's an important exception to that, where she contrasted outcomes with the Czech and Slovak republics. But for the most part, negative cases, which are countries that could have lustrated but didn't, haven't received a lot of attention. Also, some positive cases, so countries that did lustrate, have received relatively little attention, and I would say most of the Baltic states plus Southeastern Europe fall into that category. I believe there's been an overemphasis on explanatory factors of things that happened after the transition, without looking too much at the period under communism as a factor that determines whether or not these countries adopt these laws. And so with that in mind, my research questions are, under what conditions is lustration likely to be adopted, and when is it likely to be enforced? To answer that question, I actually inspired by Nadya's paper. I take a research design that uses a most similar cases comparison design. So what that means is you select countries that are most similar on a set of factors that you believe are explanatory of your outcome, but then they're different in terms of the outcomes. For my purposes, I chose countries from the former Yugoslavia who had a similar, though not entirely the same, experience under communism as part of a federal state, but they've had different outcomes in terms of adopting these laws. So the three I'm looking at: Croatia, which proposed a lustration bill in the late 90s on 2 occasions. It was not adopted either time. Serbia, which did adopt a lustration law in 2003, but it was never enforced, and it expired, having been on the books for 10 years as it was intended, but never implemented. And then Macedonia, which, as I've said, adopted a law in 2008, and they've vigorously enforced it. So you have these countries that are similar on the front end and different on the back end, and that's the philosophy behind the most similar cases design. To analyze these cases, I'm using what's called the strategic narrative method, which is something developed by our former colleague, Robin Stryker, which is where you take an anomalous case. Your starting point is an anomalous case, and with respect both to theory and also empirically anomalous. And you can use that case to build theory, generate new hypotheses, new concepts, and new findings. And my goal is to convince you that Croatia is such an anomalous case, and then go from there. And then we'll look at the other countries in turn, because it's a multi-phase process. So Croatia is anomalous with respect to theory, and what I mean by this is Croatia is a country that, based on existing theories, we would assume or we would predict Croatia would have adopted lustration, and yet they didn't. So there's 3 arguments that I would make as to why it should have adopted lustration, based on current theory. So one is the mode of transition to democracy. Croatia underwent what Samuel Huntington would call a replacement transition. So this is when the old regime is completely replaced and there's new people in power. This is an explanation that has been used in other instances. So, for example, Catherine Sickink will say that you contrast countries like Argentina and Uruguay. They had different types of transitions. Argentina had this replacement transition, so they had trials. Uruguay didn't, so the junta was able to negotiate amnesty, and they were shielded from accountability. So having a replacement transition, you're more likely, theoretically, to have accountability. A second argument is, this comes from the work of Lavinia Stan. It has to do with the strength of the anti-communist opposition and also repression of elites, which I'm arguing that, at least in Croatia, there was a strong anti-communist movement that sprang up in what was called the Croatian Spring. Right-wing political parties are more likely to adopt these laws than left parties. So when a right-wing party is in power, you would expect there to be lustration. The party in power, the party in question is the Croatian Democratic Union. They have, there's this data set that codes political party manifestos on a left-right scale. So positive 100 would be all the way to the right, negative 100 would be all the way to the left, and they are at positive 47. So it's a right-wing country. For comparison, the U.S. Republican Party in 1996, which was around this time, was plus 24, so further to the right. But that was not the party that introduced the bill. It was another party called the Croatian Party of Rights, which was a minority, marginal party. They only had 4 seats in parliament. But they made one of their arguments for adopting this law, which was actually very disingenuous. They said that passing this law would help Croatia accede to the European Union and NATO. And I say that's disingenuous because the Croatian Party of Rights actually opposed the EU and NATO and want Croatia to be part of them, but they were anti-communist and wanted to pass this law, which didn't happen. The strategic narrative method requires that you reframe a case. When your existing theories fail, you reframe along new theoretical lines. What I'm trying to do is to reframe it in terms of looking at whether and how the state makes use of and regulates the security sector. What time did I start?
I must admit, I did not look, I should have, but another 8 minutes,
Okay.
8-9 minutes.
I may not have time to dwell on this point, but there was in 1966 a major shakeup in the government in Yugoslavia. Aleksandar Rankovic, who was a Serb, an ethnic Serb, was the Minister of Internal Affairs, and he was in charge of the secret police. Widely tapped to have been a successor to Tito, but because of various abuses of power on Rankovic's part, Tito fired him and purged his supporters from the party. And what I'm arguing is that that set in motion a chain of events that I think has made lustration not very possible in Croatia. And this draws on the concept from political sociology of policy feedback and inertia. Basically, what happened is that once Croatia transitioned, and they had elections in 1990, where Tudjman came to power, and then just about a year later, the war started. That war, I think, really prevented lustrating the secret police. It seemed logical. This is former president of a human rights organization said it seemed logical when you're at war, when you're under attack, that intelligence structures cannot be changed, but must be left as they are. Also, post-Rankovic, the UDBA really ramped up a campaign of assassinations that they carried out mostly in the West, especially in West Germany, against Croats. These killings were carried out by the Zagreb unit of the UDBA. So these are the people that were retained once the war broke out in the 90s. And some of them became very close to people, including Franja Tudjman's son, who they worked for. And so these people have essentially been shielded, by developing these relationships, they've been shielded from accountability. That sort of is changing possibly with now that Croatia's joined the EU, but I don't think I have time to go into that. But the case of Croatia lets me conclude that reforms to the security sector, including lustration, are not likely to occur when that sector must be built under rapidly exigent circumstances such as war. When personnel are retained and form close ties to the new regime, they're likely to be shielded from accountability. Okay, and then I'll move on quickly to Serbia. So this is very quick background. Serbia underwent a significant transition in 2000, and then the prime minister who came to power after that, Zoran Đinđić, was assassinated a couple of years later. And in the wake of his assassination was when Serbia adopted its lustration law. I'll pause for a second to show that the reason that the law wasn't enforced in Serbia, we can't say that it was because no one wanted it to be. This is 2009 survey data that's nationally representative of Serbia. And you see lustration is actually the most popular transitional justice mechanism of the ones that were asked about, 82%. Support, and that includes 79% among ethnic Serbs who tend to be the most suspicious of transitional justice. I did an analysis that I don't think I have time to talk about. I'll go into, so the case of Croatia really explained, I think, the usefulness of a policy feedback path dependency argument. I think the case of Serbia illustrates the limits of that type of argument. And so here are a combination of several factors that led to why passing the law didn't end up being constraining. People didn't have to follow it. So this comes from someone else's work, and I've added a couple of my own categories here. But one is weak policy design. The Serbian law had a very vague definition of human rights violations. Another point is there were institutional inadequacies. The Serbian commission that was supposed to carry out this work it was never fully staffed. There were supposed to be 8 people to it. In the commission, only 7 were named to it. Poor timing in the sense that although the timing was good in that the assassination of the Prime Minister, I think, really allowed the law to get passed. But the use of emergency procedures to push through the law alienated the opposition, who then won the elections 6 months later, so timing was not good. Then there's this category that I'm calling regulatory capture, which is basically a sort of fox guarding the henhouse situation. So the people who came to power after that should have been the ones really who were most likely to be subject to the law, but instead they were tasked with enforcing the law. So that didn't happen. And then also I would say that I call this stoking conspiracy theories. You could also give it the name of like misinformation or disinformation, but it just so happened that at the time that the Parliament was debating the Lustration law, George Soros was in Belgrade visiting, and he, on the day of the debate, made a statement about Kosovo that basically said that Serbia and Kosovo should part ways. This was very unpopular, and so he was, and also people had thought that Soros was behind the October 2000 revolution that had ousted Milosevic. So people tied these two things together, or tied Soros's involvement to these, and made it seem as though he was some puppet master that was pulling the strings to get this through. And I will try to compare Macedonia and say, so Macedonia is the case where there is actual enforcement of the Lustration law, and show that it has the opposite, is the opposite on all these points with respect to Serbia. So Macedonia's law has a stronger policy design. Instead of making an ambiguous appeal to human rights violations, they have framed lustration as basically employment regulation, just something you need to do to get a job, just like getting a degree or other qualification. There is adequate institutional support, and I was able to interview members of the Lustration Commission in Macedonia. Timing, they have had this party that has, the right-wing party has been in power for since 2006, so there's been no change in terms of bringing in a new party that would otherwise not want to enforce the law. I think Macedonia has gone in some ways too far the other direction. So rather than regulatory capture, there's been abuse of the law. They've been lustrating too many people rather than too few. And then actually George Soros comes up again. His organization actually hit the Open Society Foundation that he founded. They have a branch in Skopje, and they initially in the early 2000s were very supportive of lustration. They wanted it to happen. But then they switched their mind, and this was kind of puzzling. And in the wake of that, one of the things that happened was the head of that organization in Skopje was outed as a police collaborator, and so it made people wonder, did they change their position in order to shield him? Who knows? And who knows if he really was a collaborator, but they named him as such. So, in conclusion, Croatia, I believe, shows the possibilities of a path dependency argument. Serbia illustrates the limits of it. Lustration is a process, I believe, that's largely driven by internal processes, democratization, legal structures, and under certain conditions, policy feedback or policy legacies. The important international factors that drive lustration appear to come from the regional level rather than the global. And this is something I didn't have time to talk about, but I think it's more contingent upon a state's ability to see its own history as similar to or connected with that of other states in the region. So Macedonia's ability to see itself as similar to, for example, East Germany, rather than some kind of global script that's coming down saying, you need to do this, you need to lustrate. So, thank you.
Thank you, Ryan, very much. Our next speaker is Adam Czarnota. Adam Czarnota is internationally one of the, I'd say, most renowned sociologists of law. He comes to us simultaneously from Spain, Poland, and Australia. Very hard to fathom, but if I give you the specifics, which you find in your program too, he is the scientific director of the International Institute for the Sociology of Law in Oñati, in the Basque Country. He is a professor of law at the University of New South Wales in Sydney, Australia.
On leave.
On leave from there to spend how many years as director in Oñati? 3 years in Oñati. He is also professor of law at the University of Białystok in Poland. He teaches philosophy of law, sociology of law, and the history of legal and political ideas and comparative law. And he has published widely in all of these areas, and I think this is very much reflected in the very stimulating paper that I had the great fortune to read before the meeting. Thank you very much.
Thank you very much. Thanks for the introduction. But first of all, thanks for the invitation. It was a real pleasure. I like this sort of the cameral setting and no-nonsense discussion about ideas, not so much show-off, like the big conferences, but real, touching and exchanging of arguments, which took place yesterday and I hope will take place today as well. And then after this introduction, I have to inform now everybody, especially Joachim, that I decided to change the paper, what I'm going to talk about. So why? Let me explain why. Why? Because what I did in the paper I sent it here, it's been distributed, is a sort of the universal problem of the relation between the memory and legal institutions. And one of the issues there, which I try to struggle or to tackle actually, is the issue that legal system, the Western legal tradition, is not prepared actually to cope with the problem of the collective memories. So what is needed is a peculiar change, and I observe, and it's in the paper I try to argue that it's possible to observe across the globe the rise of the quasi-judicial institutions, which are more free. They look like courts, they behave like courts, but at the same time they are not bound by the rules. It means they are much more sensible, empathic to the problem of the experiences from the past. That's a universal part, right? Now the more particular part, because this conference here is about the Central Eastern Europe, as I understand. Therefore, what I want to do became a more particular, not so much universal, but focus only on the problem of the relation between the past, not so much collective memory maybe, but the past, on dealing with the past and the legal institutions in Central Eastern Europe. Why now? Why? Everyone knows that last year there was the 25th anniversary of the breakthrough, it means the collapse of the Berlin Wall. Each Poles are not very happy with this expression, collapse of the Berlin Wall. Why? Because they were first, as they claim. It means the first which set up this round table talk, and they put an example for other parts of the Central Eastern Europe. But let's follow. It means after 1989, in all of those former communist countries of Central Eastern Europe, there was the peculiar legal expression of transformation or change. What that means, this legal expression, that it's been catched by the one word, basically, or two words, rule of law. Surprisingly, there was not a discourse of human rights, but the discourse of human rights is being replaced by the new type of discourse about the rule of law and the institutional setting. It seems to me it has some sort of the it is important to observe this shift, because the shift also is global, it seems to me. It means that the global scale, we move from the 70s and 80s, when the rule of law played an important role, so like human rights, to the rule of law, which means stability as such. Even I was told by one of my colleagues that, that in the World Bank there's a special unit of the young, guys working on rule of law, who try to develop the strategies, how to plant the institutions in the countries in trouble. So that's one thing, rule of law. In the Central Eastern European manifestation of rule of law, there was a talk not so much about the rule of law in the Anglo-Saxon way, common law sense, but on the law-governed state. And the first wave of the amendments to the Constitution, that was the only amendment that from this point on, this state, Republic of Poland or Republic of Hungary, is a rule of law or law-governed state. Now, was this right to make such quick amendments or wrong? My assessment now, 25 years later, is it was wrong. Why it was wrong? Because it's established basically some sort of the weapon for all those perpetrators and wrongdoers to defend themselves. Which means the first wave of amendments which institutionalize formally the law-governed state, at the same time put obstacles to any type of the serious transitional justice strategies that they were not implemented in a serious way, which means was an acceptance of what was going on. But now let's go maybe in a few minutes how the people, what's the ruling elites, how they thought about the rule of law at the time. That first of all, the idea was that after the removal of the communism, and if we improve law, there was a production of the proper law, then the people will start to use it. It was wrong. There is a very good research made by the American scholar called Henley. She spent a few years in some factory in Siberia, and she observed why the management in the factory tried to convince workers to use a labor law, and they didn't want to. Which means, what she concluded, there was a supply of law, but not demand of law. Now the question, why not demand of law? As was mentioned by Joachim, I am this sociologist of law, sociological scholar. And probably there's only one discipline which was developed purely or invented in Central Eastern Europe. On the one hand, in Czerniowcy, I mean Eugene Ehrlich. On the other hand, Petrzycki in Petersburg, right? Why? Precisely because one of the particularity of Central Eastern Europe is a huge clash between informal norms and rules and the formal norms and rules. There was no demand for the formal law because people, citizens, prefer to act in the informal way, outside the formally established state or positive law. So that was the understanding of, so that the first mistake. Then the second maybe, but obstacles in the implementation of rule of law, is being connected with the institutional dimension as such, which means that I want to spend a few minutes talking about the functionality and dysfunctionality of the courts. As you know, only one country which was lucky enough to have a spare personnel was Germany. It means that West Germany, the first, dissolved all law faculties in the former DDR. They didn't rehire any person. No single person was rehired. And they also fired all judges and the public prosecutors. But Germany was lucky because it possessed this huge army of the personnel, people willing basically to move to the east and embark on the quick career. Now if you look at Romania, Bulgaria, Poland, Slovakia, on Czech Republic, they were not so lucky. It means there was no replacement personnel. It was impossible to hire or bring somebody from other countries. Even the linguistic obstacles as such. Therefore, the first issue was what to do with the compromise judiciary. As you know, the judiciary was compromised in order to make a career in the communist regime, in the courts. Then it was necessary to be a member of the Communist Party, and to high degree also, necessary was to make a moral compromises. There was a sort of so-called telephone law. It means law which was dictated by the committees of the party through the telephone to the judges. So what's happened? Only one particular countries, they choose different type of strategies, but in case of Poland, which was probably the first, there was also a naive way of thinking that if we exchange, or if we provide judiciary with some institution which will guarantee autonomy, then the judiciary will clean itself. Not at all. It means what's happened, it means judiciary and the creation of autonomy provide a strength, and judiciary did not remove people who were compromised. Only one court, which was totally set up or dissolved totally, all judges were fired and the new were hired, was the Supreme Court of the Polish Republic. Who replaced the former judges? Academics. It means the people from the law school as not compromised to such degree as the former judges, right? So that's a second issue, means that connected with the difficulties with the implementation of rule of law. But then I now try to go outside the legal institutions and look at the specificity, basically, of the post-communist transformation in Central Eastern Europe. One of the, it seems to me, there's a different, there's a tendency, basically, to look at transformation from the universal point of view. So let's say, especially in the TJ, transitional justice approach. Let's say transformation in Argentina is similar, let's say, to transformation in Georgia, from the point of view of implementation of some strategies of transitional justice. Wrong. Why wrong? Because what happened actually in transformation in Central Eastern Europe was a privatization of the police state. Who privatized the police state? Police, precisely, secret police. They played the most important role, and they were professional. There was only one group in the entire state which actually knew how the banking system operates. They got the contact with outside world and so on and so on. But the process before 1989 in Poland and after 1989 in other countries was a quick process of privatization of the state. Remember, property was a common property. Now it became a private property. What does that mean? That the former members of the apparatus of oppression, they simply became an owner of the huge wealth, which means very quickly economical position is being translated also to improve their own political position. And the weapon to defend there was precisely this thinking about rule of law. It means we can't touch them, we can't do anything now because we are law governed state, which means all other measures will be declared unconstitutional and against the rule of law provisions in the constitution. But that's how this privatization of the police state, it seems to me, play quite important role in thinking about the problems of transformation in Central Eastern Europe. Then only one courts actually, which play important role, and we talk about these functionalities and dysfunctionalities, and a quite successful role, they are constitutional courts. I don't know if you are familiar from the legal point of view, there is a constitutionality of the legal acts in Central Eastern Europe is based on the so-called Kelsenian model, which means that in abstracto, not in concreto like in USA, right? But is a few only officials are entitled to check to demand the check of the constitutionality of the acts. And there's a special court which declare upon law, not the facts only, declaring this law constitutional or unconstitutional. The most powerful court for about 10 years on the earth was the Hungarian Constitutional Court under the leadership of the Justice Sólyom. Later on, he became a president of the Republic of Hungary as well. But I would want to put your attention to the two rulings, actually, which happened at the same time. It's one of them, big, nice phrase coined by the Hungarian Constitutional Court, was that Hungarian court claimed that the Hungarian revolution was a revolution of rule of law. At the end of citation. Which means what the court claimed, that it's impossible to adopt any extraordinary measure to cope with the past, and especially to punish perpetrators, because the most important value is the legal certainty. And the legal certainty is the aim, the essence, actually, of rule of law. Then at the same time, precisely the next month, the Czech Constitutional Court adopted totally opposite ruling, a 180% opposite, claiming that legal certainty is the value, it's true, but at the same time, more important is a material justice, which means that if we want to build a law-governed state, rule of law, therefore, it is necessary to provide material justice to the citizens. which opened the road actually to acceptance of the lustration, small and big lustration law in the Czech Republic, Czechoslovakia, as a constitutional, not unconstitutional as in the case of Hungary. And then the next step, what I want to say is that, how many minutes do I have?
You have another 10 minutes, 10, 12, 13 minutes.
Okay, great. So the next step is dealing with the past, which means it's quite interesting that the discourse about transitional justice does not exist in Central Eastern Europe. Nobody is using such expression. But what they call about is dealing with the past. It means that all these issues, the policies, strategies, how to cope with the past issues. So now, before my talk, my colleague talked about the lustration. So I don't want to repeat this lustration. But it seems to me that from the structural point of view, when we talk about the transitional problems in the post-communist world, then we have to talk about a few issues. The first issue is a relationship between the old and the new regime, especially the legal relation between the past regime, communist regime, and the new one after 1989. And the second issue is connected more with traditional transitional justice measures, like retributive justice for crime committed under the former regime, right? And then lustration, then rehabilitation and compensation for the victims of communist regime, and last but not least, crucial point as it seems to me, is the restitution of property, the problem of the property after communism. So the first one, it means relation between the old and the new regime. In the majority of countries, probably with one exception of Romania and the Baltic states is the second. I'm not touching Yugoslavia because it's a different way of transition. And I'm not touching the former Soviet except the Baltic state republics. But let's say going from Poland, Czechoslovakia down to Hungary and Bulgaria, the way in which the transformation took place or started were roundtable talks. And what was the roundtable talks was formally the negotiation about the new arrangement. But now if we look from the legal point of view, all these agreements which the leaders of the opposition agreed with the former communism, right, during the roundtable talk, they create a super constitution. It means the outcome of that was the agreement what will be in the next constitution. So the agreement signed in the roundtable talk possessed a normative higher character. It means pacta sunt servanda, we promise, we have to deliver. Right? But what is from the political point of view, in some countries, first time in history, since 1944, dissidents and leaders of the opposition, they provide legitimacy for the communist elites. They sat down together at the same table, which means there was no revolution at all. There was a fake revolution. That was a negotiated revolution. But negotiated by whom? Now, what was the legitimacy of those leaders of the opposition? And none of them, actually, they were not elected by the people. They received some support, that's true, but the support varied from country to country. Zhelyu, who passed away a few weeks ago in Bulgaria, he was simply found somewhere by the secret police and was told that you are the now leader of the opposition at the round table. On the very beginning, he didn't want to, but in the end, he agreed. Right? Of course, I exaggerate a bit. In Poland, as you know, that was a 10 million movement, Solidarity, but the movement was in 80-81, not in 88-89. In 88-89, those people represented themselves, not the 10 million strong mass movement. Therefore, from the very beginning, some part of the society, some part of the political spectrum, another small one actually, because it seems to me is about 50%, claim that it was an original sin. It means negotiation with the communists and signing these roundtable talk agreements. So this, as you know, the relation now between the old regime and the new regime, from the legal point of view, is based on the continuity, recognition of the old type of law, and the transmission of this old type of law to the new, what they call Third Republic or Fourth Republic. Numbers are not important. It means it's a transition, continuation from one to another, with a plenty of repercussion. What repercussion? That on the discrepancy between what is in the people's consciousness, it means memory, and what actually exists on the legal level. Which means this is being, to change the existing law is a quite difficult process. I could give you only some statistical data. It is before the accession to European Union in 2004, all of those countries who joined Union at the time, they were obliged to adjust their law to the acquis communautaire. Acquis communautaire means all this European Union, let's say, law is about 100,000 pages. 100,000 pages. Adjust this law, it takes ages, actually. In Spain, about 1,500 lawyers worked before the Spain joined EU, European Community at the time, to adjust the Spanish law. In the case of, let's say, Poland, Czechoslovakia, Hungary, they didn't have enough personal resources. But I only show that this way of the transition, of the legal continuity, really put another obstacles actually to the change, or real change. Now the decommunization. Maybe I won't touch lustration because it's been said here, but on a few comments later on. But decommunization. It means decommunization in opposition to lustration is a removal of the former political personnel from the public sphere. Right? It means when lustration, how is understood, is only that those people who were compromised by the collaboration with secret services. So did the decommunization took place in the post-communist world? Well, probably is the best way is to look at the secret services, because it was a pillar of the state and the military. The communization didn't take place actually. It means the most important, and most importantly in the secret services. There was attempt to change them, but in plenty of these countries you will hear the opinion that basically the secret services are making a political agenda, right? Which means they control. So I mean, the communization took place in some sort of the most visible areas, like let's say public TVs, compromised faces have been removed. As I said, on the level of the High Court, Supreme Courts, but below it did not happen. And then the next element of the transitional justice measure is access to the secret police files. As you know, this regulation with access is different from country to country. So there is a full access, let's say, in Germany, but not full access in Poland. In Poland, there was from the very beginning problem, but very quickly was regulated that what was set up in Poland was the Institute for National Remembrance. And the Institute for National Remembrance is a peculiar institution. Why peculiar? Because it's composed, it possesses also prosecutorial power, which means they are public prosecutors working on the files. And researchers, journalists, they have access to files as well as victims, right? So in the past, to have access to files was necessary to apply for the status of the victim. If they check that really in the archives of the former Ministry for Internal Affairs, this person is noted, and then they grant the status of the victim, and such person has access to full files, including the names of those who spy upon this person. But this access slowly is being more and more reduced, not open actually, but reduced and reduced. So that's not this measure, actually, it seems to me, does not work very well. What does work well is this educational pillar of the Institute of National Remembrance, which means that researchers, historians, sociologists, they produce book after books based on that archives. Maybe I should add that to discussion yesterday that the 2 big volumes about Jedwabne after Jan Gross books were published by these historians with full documents, full name of the people, and full information what was in the archives of the Ministry for Internal Affairs. So it means they not only work on the victims of communism, but also the victims before communism as well. But the worst situation actually is with the retributive justice. It means retributive justice is something which did not take place in none of these countries. It is probably example is, again using from Poland, is that General Jaruzelski, who passed away about a few months ago, was buried with a full state honor and full state and military honor. At the same time, you know, he was responsible for implementation of martial law and for orders to shoot to the workers, to shoot workers. Right? I mean, that's, you could say, is a big name, but on the lower level, it means only few foot soldiers, let's say, those who were involved in the tortures in the 40s and 50s were sentenced to prison. Bigger name, not at all. And as I mentioned, last but not least, is a property problem. And it seems to me that especially in the case of Central Eastern Europe, post-communist Europe, that's a crucial issue. It means who owned the property, why, for instance. Is one exception of Germany, none of these countries adopted the restitution law. Czechoslovakia adopted so-called small restitution law. It means a corner shops, but there was a problem with the big restitution, which means the restitution of property in nature. And what they discuss is a compensation, but not restitution. And my answer is that basically that's an economical interest. Somebody could claim it's a functionalist approach, but it's true. It means it's a functional from the point of view of those who rule, the ruling elites of this country, which means, as I mentioned earlier, this privatization of the police state, which means that these elites are not interested actually in the restitution of property in nature. And it's not only the question of the restitution of property, of private property, but also a communal property. So one of the interesting examples, which I know from Poland, is that Hutus, right? It means this people in the mountains, they own the mountains and forests. The forest is being privatized, now is in private hands. And all their claims to restitute the property, which was confiscated in the 1946-47, is simply thrown out to the rubbish bin by the courts. So in the few conclusion that there is a huge discrepancy between the expectation of people based on the memories. The memories what's happened and what they want to achieve, and what actually in these law-governed states at the moment is going on. Thank you.
Thank you for listening to 3 fascinating papers, I think. And from Adam, I got the benefit of 2 papers, one by way of reading, one by way of presentation. So that's an extra bonus I hadn't counted on. Linking this to my initial question, are we going to be is the optimistic perspective on transitional justice going to be supported by today's presentations, or the darker perspective that I encountered at the conference? And also, I think we have to conclude that the more pessimistic view of transitional justice has been supported by these 3 papers. Let me make a personal comment, and I will be just brief for just for 1 or 2 minutes, so we have some time for general conversation. I was born in 1951 in a country that 6 years earlier had been governed by the Nazi state. During my first 15 years of life, the Holocaust and the Nazi rule were silenced. We know, this goes beyond the personal now, from opinion surveys, that in the years afterward, immediate years after World War II, there was an amazing level of positive statements about Adolf Hitler. There was an amazing level of negative attitudes about democracy. These patterns of opinion changed in the course of 20, 25 years. There were period effects, meaning that the same cohorts developed more negative attitudes toward the Nazi regime and more positive attitudes toward democracy. There were especially cohort effects, meaning that younger cohorts grew up with much more negative orientations. This history of communist rule in Eastern Europe is 25 years behind us now. It's a relatively recent history, and I'm looking for bright signs, desperately, and I see bright signs maybe in Ryan's talk, who finds that lustration, if done in a particular way, can work, even in the case of Macedonia, even if there are some critical sentiments. I find very modest signs of optimism in Nadya's pessimistic talk, because at least the young generation, when asked in opinion surveys, well, the dark side is that they know nothing about the fascist history of their country. The positive side is that they at least do not have positive attitudes, despite the efforts of neo-fascists to celebrate the fascist state. Those efforts don't seem to succeed. That may be a small sign of hope. With Adam, about a year ago, or was it a little less, we had Devin Penders, historian from Boston College here, who has done wonderful work on the Frankfurt-Auschwitz trial, and afterwards moved into a new project comparing Nazi trials in East and West Germany. And I think in East Germany he counted exactly what you were hoping for. He counted a system, a judicial system, that was not very concerned with due process, with the rule of law, but that meted judgments against Nazi perpetrators that somehow seem reasonable, at least to us. There can never be satisfying judgments in a criminal court, but at least somewhat reasonable. In West Germany, the courts are very much oriented toward due process and rule of law, and came out with judgments against Nazi perpetrators that seem absolutely unsatisfactory. Penders' argument is that despite this level of dissatisfaction, the observance of the rule of law and due process contributed to a democratization of judicial culture, at least in the western part of the country. So, you see, I am searching for signs of hope, and I hope that these signs that I see are not just my illusions, but are somewhat grounded in empirical reality. I thank you all very much, and please raise your hands and let's hear some questions. Yes, please.
Just as a quick comment to what you mentioned about the development in Western Germany, I think it's closely linked to the economic development and prosperity, because I think you can clearly also see these things in Poland in public opinion surveys. You can draw a very direct link between the attitudes towards the changes since '89 and the economic or socio-economic position of respondents.
Yes.
Just a quick comment. And as a question to Adam, I really like your estimate about the focus on the rule of law, and I was wondering if you have a guess what the reason for this focus is. If they did the agent kind of take the Western liberal ideology on the rule of law for too literally, or what were the reasons?
Maybe collect maybe 2 or 3 questions, Elena, and then Tom.
So for Ryan, on the issue of lustration, I guess I'm not that shocked that there was nothing in Serbia and Croatia, and the lustration in Macedonia is really profoundly troubling. I mean, I don't even know. I wouldn't call that a mechanism of transition for justice, what they're doing. I mean, it's a witch hunt, and it's carried out by a very dominant political party that hasn't changed hands in 15 years. But in Serbia and Croatia, the issue of lustration seems to me, it's more about why has nothing been done with the members of the security apparatus of the recent wars that have all merged and morphed quite seamlessly into the new apparatus of force of Serbia and Croatia post the recent wars, than what to do with the members of UDBA in the 1960s. I mean, these people are now 80, 90 years old. But there was no attempt to clear the ranks of current police officers and current military personnel who have committed war crimes just 10 years ago. So it seems to me that unless there was a political interest in opening those files, which never was, partly because part of the transition post-Tudjman and post-Milosevic was based on the support of these services, then there's no way that any attempt at lustration could have worked. So I wonder kind of what you found in your research on any attempt to do lustration for the more recent violence.
Let's get one more question, then we'll go. Please, Tom.
Yeah, Joachim, I appreciate, sort of like to rephrase your attitude maybe, and I appreciate very much your effort to put this in a to suggest long-term processes that are going on. So, papers are great, to learn much. Adam, how do you conceptualize the cultural, let's say, ramifications of the move to a law-governed state? Is it possible that this change is in fact a very long-term one with effects, some of which are visible, some are not visible? Where do you see or is it possible to think of this law-governed state as having multiple effects in different areas of everyday life? And for example, is it possible that the law-governed state promulgated by the shift that you talked about has created a kind of new confidence in the nature of everyday life that is itself a kind of positive shift, maybe?
So, Adam, shall we start with you and go along?
Thank you. Thank you for the questions. Well, maybe start with the comment by Joachim. Change of generation. It means, it seems to me, I reduce not to the longue durée, not to the long perspective, but to the change of generation. It is necessary. Probably it is, it seems to me. Even, everybody probably read the Bible, and that was this story about this, this escape from Egyptian slavery, but sociological interpretation of that is basically to talk about generation of the different people who get to the promised land in the end, to build something new. So it means that this slave type of the characters were not ready yet to enter the promised land. We try to find something very quickly here, what is changing. So it seems to me that suggestion that, no, let's postpone, should be adapted to everything. It means all those assessment of the nationalistic movement, change, manipulation of history are not work of some institutions. So I agree that today is possibly, let's say, if we look from the point of view of the change of the generation. But then the second element is that what are the cultural questions, the effects of the rule of law? For sure there are some positive, but my measure is such that it's basically relatively easy if we look sociologically at the type of relations which are necessary for the law-governed state. The first type of relation is a state institution to state institutions, and that's easy to do, basically. It means You make a regulation, you adopt some law which regulates relation between the particular powers or administration and the state. And control, implement, that's easy. But then the second is state institutions to citizens and citizen to state institution. That's much more difficult. It means why? It requires some sort of the peculiar institutional culture. So to speak, it means majority of, probably with exception of Bohemia, all societies from the Baltic states down to the Balkans, they are post-peasant society. Which means, what I mean is post-peasant, with a peculiar type of non-citizens culture. Which means citizens are peasants, they ask for something, but they don't treat themselves as a career of rights. That I go to the state institution and I request, please treat me with dignity because I am a citizen. I deserve it. And that 25 years in the collapse of communism didn't change. In opposite, I will tell you that in the past people complained, let's say before the communists, to the local parish priest. During the communists they complained to the local secretary of the party, and now that they complain to the ombudsman, which means it's a mushrooming of this institution of the complaint, but not demanding some rights. So on the cultural side, implementation of rule of law, it seems to me I can't see the change. It means the change towards this citizens type of culture. Then, maybe I should say in the form of the anecdote, it means 90 or 91, Joseph Raz is a philosopher and a jurist from Oxford University, gave a talk in Budapest about the rule of law. And after the talk, some local scholars, humbly asked him, "So Professor Raz, tell us, so what we supposed to do to get the rule of law?" Because it's a big value. And Raz looked at him and said, "Wait 1,000 years and you will get it." And that's, it seems to me, is a totally irresponsible answer, because we could wait for the Godot, but we'll never arrive, right? So it means that it seems to me that my focus is basically that it's possible to design institutions which will not block, but unblock some social processes and speed up these social processes. And a last quick answer to the last question, basically, it means that treatment of rule of law, as I understand, means why it did not work there. For plenty of different reasons, but one of the reasons is that rule of law is too serious issue to be left for lawyers, which means it requires special type of the social ontology, social background, cultural background. And it happens that it was treated purely in the black letter way, in the positivistic way. Right? Therefore, it does not work. It's an abuse of law using the expression of law-governed state. So probably that's all questions.
All right, thank you very much, Adam. Ryan, please.
In your comments, Joachim, you had said that you took solace or comfort from that Lustration was working in Macedonia, and I didn't mean to leave that impression.
I know.
I agree with Jelena that it is a witch hunt.
Reread those pages.
Because I did speak to people who had been outed or exposed, and sort of their reputation, at least, is ruined and seemingly on very thin evidence. Why was nothing done in terms of reforming security apparatus from the recent wars? I think that's a really good question. I mean, when I went to Belgrade, and one woman who I interviewed is a law professor, and she was in the 90s involved in like anti-Milosevic protests, and she was at one point beaten severely by a police officer who is now, I guess, the head of the police in Belgrade. And she occasionally has to have professional interactions with him. So, I mean, there are people who I think would like that to happen. I don't, as to why it's not happening, I don't know. Maybe we could look at the case of Bosnia as an example, because Bosnia is the one case where there was a clear push from the international community to have a form of lustration post the conflict, and it was written into the Dayton Peace Agreement. been some lustration like of the prosecutor's offices in Bosnia, and that didn't happen for whatever reason in Serbia. It was all about compliance with the ICTY, hand over the people who are on the land. The other thing is that's puzzling about it to me is that, you know, they did pass this law, it did exist, and as I have said, I couldn't find any external pressure on them to do so. So it puzzles me as to why would they pass the law and then not do anything about it.
There was a change of guard. This was under Gingic in 2003, and there was this,
Just that,
his
yeah.
push for openness, and then he got killed, and there was that.
And so the survey data that I showed briefly and didn't really discuss, there was large support for lustration, and I should say that in the context of people responding to that survey, most of the questions were about the ICTY, so they probably were thinking, you know, when they were asked, should people be banned from office for human rights violations, they probably were thinking more about the recent wars than about the communist period. And it had large support, and even when I so there were questions on that survey that asked people if they had heard of various events, like atrocities like the siege of Sarajevo or whatever. And then if you said yes, then you were asked, do you believe it happened? And then if you believed it happened, then you were asked, was it a war crime or was it an inevitability of war? And they asked that about 22 different atrocities in that survey. And what I did was look at, I basically sorted people based on their responses into 4 groups. So there were the low information voters, or low information people who hadn't heard of very much, the skeptics who didn't believe much had happened, what I called the belligerents, who were the people who believed they were inevitabilities of war, and then the critics who believed they were war crimes. And of those 4 groups, I controlled for a lot of things, and there was no difference in the odds ratios in terms of who was supportive of lustration. There were big differences in terms of ICTY, domestic trials, apologies, whatever the truth commissions, but no difference in terms of support for lustration. So I think it still remains a puzzle to me as to why there's no lustration.
Nadya?
To respond to what you said?
If you would.
Sure. So, well, I think it's nice that you would have a positive, optimistic interpretation of, or...
No, just a glimpse of light.
Okay. I mean, I not to try to darken that, but there are, it's not only old former political prisoners who rally around the anniversary of the wartime state. There's unfortunately a lot of younger people who now attend these rallies, and there was also that group that I talked about, the Slovak Brotherhood, dressed up in the Lincoln Guard costumes and as Roman minorities. One of the head of that group was recently elected. I can't remember if it's the mayor, like a high level
Mayor.
In Banska Bystrica, and with a lot of public support. So I think it's worrisome if people don't know that history, that when people come with that, with an agenda that's linked to it, the ignorance can be dangerous. So.
Thank you. Now we must hear the warnings that must be heard. Alejandro, you raised your hand, please.
Thank you very much.
And then we have to close it.
Illuminating presentation, thank you. My question follows up also on the long-term processes and generation. I'd also like to bring in the larger context of the collaborative and the cases that some of the cases that we've seen last year. The fact that you are coming from Spain, so I want to raise the issue of this contraposition of rule of law versus human rights regime. In Spain, and the Spanish transition became a model for transitions. And it basically were the elites of the old regime sit together with reformers or with opposition leaders and bring a better constitution, and at the same time in Spain the amnesty. So at that time, also there was a consensus, at least among those different political actors, that stability and peace had to be prioritized over justice, or an idea of justice. Time has passed, and as in Spain and also we see that in Latin America, a new generation thinks that something that it was wrong what was done at the time, others think that that might have been right, but now it's time to revoke the amnesty law and to question fundamentally that regime of the transition, the regime of transition, which is that idea of only rule of law as amnesty and impunity. So my question is, well, what factors have influenced here? I mean, that ties into what also Lars commented. The fact that Spain has developed incredibly in the last 30 years, that Spain became European, that the human rights logic, the human rights discourse has impregnated and has a new generation has learned about that and is more aware of it. And so it's a new generation that is questioning the older one and saying, well, maybe now it's time for trials and prosecutions. We see similar phenomena in human rights activism in Latin America, particularly in those countries where there were not trials and prosecutions in the immediate aftermath of the regime change, in Chile or Uruguay. So my question to you is, what can be the factors that can bring that consensus for that shift from rule of law model to a human rights regime? And whether you would actually, I mean, what's your position on that? Because I'm not sure I understood. So she said there's a huge discrepancy between what people experience and what is actually done, but at the same time, that the legal system is not prepared to deal with the past. So these are basic questions for me.
Three more, three more questions and 3 answers. Everyone takes 1 minute, then we'll just be 10 minutes over time. So let's keep it to that. George, I think you were next.
I have a small, comment. In terms of our discussion yesterday and today, in terms of the rule of law and activities of nationalist groupings during the Second World War and after, and we talked about how does one kind of bring these memories to the point of some sort of reality and consensus. And in terms of what we've talked about, one suggestion here is that it might be a question of generations, that over the course of generations this might change. But also I think that another question that I think might be investigated in the future by various individuals interested in all of it is the kind of the level of how is the education system set up in all of these post-communist societies. And what comes to mind is after the Second World War, Germany, and I'm not a specialist in the history of post-war Germany, but Germany had experienced a period of denazification, certainly not kind of what individuals who started it wanted to start, but there was also a transformation of the educational system. And so as a consequence of this, students in Germany kind of learned things about their past which was quite critical of kind of the Nazi regime and so forth. And I would say that I would guess that the similar situation with the American occupation of Japan did not happen in Japan, or did not happen to that extent, because as you might know, as you all know, Japan is now having problems with many of its neighbors, primarily because of its interpretation of the Second World War and the fact that the Japanese do not take as much responsibility for the war in East Asia as Germany has in Europe.
Thank you.
I unfortunately have to agree with the generally dark and pessimistic view that has emerged from the panel. But in looking for glimmers of the positive, I wonder how you balance all these factors that you've discussed against the observation that most, if not all, of the post-communist countries have gone through a succession of free and apparently honest elections with negligible dispute over the outcomes. That surely is something to be viewed with some encouragement. And I'm curious how you would balance that aspect of post-communist development against all the negatives that you've emphasized this morning?
Thank you very much, Bart. Your last question, please.
Yeah, and thank you all so much, and I continue to be fascinated with the differences of the Eastern Europe and Central and Eastern European case to the Latin America case, and so and one of the things that I've been really struck by is especially the case of Slovakia and Croatia, where there's this fresh nationalism of a newly independent state that seeks to mythologize, the heroic past, that this is the come to fruition, this long dream, and it just strikes me, I guess, sorry, that one of the questions that I'm struggling with here is what's the difference in the colonial legacy with Latin America and Europe, in the sense that it's connected to this mythologizing question, in that the kind of nationalism that takes place in Latin America has to engage with the colonial past and the mythologizing of the pre-colonial era is actually an indigenous era that is an entirely different mythology than this European mythologizing, which it doesn't have to deal with any indigenous past. So this is a really raw thought, but I'm just trying to get a sense of why there is such tight insistence on nationalism in these states in a way that I don't see playing out in Latin America.
Thank you, Barb. Each of these questions would merit a half-hour discussion for sure, but I want to give maybe each of the presenters just a half a minute, maybe. 1 minute, okay. 1 minute, but what's the core response you'd like to give? Shall we start with Adam again?
Yes, thank you. So quickly, there is, when I said that legal system is not prepared, it's not only in relation to the legal system in Central Eastern Europe. Generally, the Western legal tradition is not prepared to cope with the past. It's an individual allocation of guilt, responsibility, accountability, and so on. And that's why I claim that it's a development of the quasi-judicial institutions, which are simply, they blur this border. They try to accommodate this responsibility on the higher level, chain of command, and so on. So that's one. The factors which will contribute to the shift from rule of law, formal rule of law, to the human rights, I don't know, I can't see them actually. It seems to me that transitional justice in the case of Central Eastern, post-communist Central Eastern Europe, for me used to be constitutive justice. It means without that, there is a creation of the system in which the former perpetrators, basically they control the entire system. And then if they control media, right, at the same time, so I can't see basically now any avenue how to make this shift. So it's a concentration of media in the one hand, concentration of the capital in the same hand, basically. And not important area of politics. There's a question to the fair election. Why? Politics is something which is dirty. People look at the politics and I don't want to. Turn out is not a big one. It means it used to be in 1991, not anymore. On the other hand, is one fascinating factor. It means it doesn't matter which political party won election, economical policies are the same. It means for 25 years, the same economical policy. People voted for something different. Oh, there's a minor. It means 1% from the taxation up or down, that's a minor factor. It means what was the general policy was the same. It means few issues were outside dispute. Foreign affairs, that's fine. Right? It means joining Europe and NATO. That's then the second, economical policy. Means even that when this slogan in Poland, there is no alternative to the Balcerowicz plan. There's always alternative to any plan, actually. But it seems to me that on the level of citizens, the consciousness is on the very, very low level, and basically through propaganda, everything is possible to sell. Well, only two comments, quick comments. That's a phenomenon. Why is this turn to the nationalistic feelings? And it seems that when I never done actually any research, I thought about it, but it seems to me there are two reasons. One reason is in the young states. That was a sort of the normal, it means Lithuania, it means those who receive independence now. When there was a natural movement to this nationalistic, it means get together, right? But now what we observe is in the so-called old states, the similar movement. Why? Probably, it seems to me, is a sort of the only one in this individualistic, relativistic world at the moment, with no some stable elements. Only one phenomenon which provides safety and belonging is the nation. That's why is this push towards being part of something bigger, not be left alone. And a comment on Ryan. Sorry for that. It is, according to my research, you mentioned here, if I understood correctly, that lustration law has been criticized by the European Court of Justice. No, what according to my reading of from a few years ago, not the recent case, is true, that in the two cases only, there was a critique. So the one construction used by the European Court of Justice was that lustration is okay, even more than okay, and they used the German Constitutional Court concept that democracy has a right to defend itself, which means for some times the normal operation of human rights could be suspended in order to build up democracy. There was two critiques, Czarnota versus the Republic of Lithuania, and in this case the European Court of Justice said that the lustration law in Lithuania is too broad. It means it's going outside the public sphere and also includes the private sphere. It should be restrained only to the public sphere. And the second, in the case of can't remember another name, in Czech Republic, the Czechs adopted lustration law originally for 10 years, then extended for another 10 years, and now forever. So there was this timing problem. How long we are talking about transformation? It means the need for the suspension of the normal operation of human rights.
Thank you, Adam.
Ryan? Just on that, so I was meant to say that they haven't said lustration itself is a problem, but that in the particular cases brought before them, they had always ruled in favor of the lustrated person, and that's an article by Cynthia Horn that was in Law and Social Inquiry. That's where that came from. These other questions are all great. I don't feel qualified to answer them. Clean elections, I don't know if I think there's other things you could look at besides elections to see like how well the democracy is developing. People that I have been in touch with in Belgrade tell me that media censorship is worse there today than it was during the 90s. I don't know if that's true, but so I feel like there's other things happening even if maybe the elections aren't working. I don't know enough about Latin America to comment about that. Sorry.
Nadya, any comment on the election question maybe or anything else?
Well, I guess I don't know that you have to have a full confrontation with the past to have a relatively healthy democracy. So I think that there are lots of positive changes in the region, and these are darker elements of much broader pictures that have many positive things. So I don't think that any of us, well, I didn't intend to give a sense that even Slovakia is that its democracy isn't healthy in important ways, but these are worrisome aspects, but every country in the United States has not confronted lots of important parts of its own past. It's problematic, but it doesn't mean that it's not a solid democracy. I think with regard to education, that's interesting with Slovakia because when the SNS is in coalition with the governments, it always wants the education portfolio and gets it often. And so it has some influence. And people who write for this Svedectvo have also been like authors of textbooks. So depending on who's kind of in charge, it can be helpful to have education, but it can also be this message, this sort of whitewashing message has come through the educational system to a certain extent, because the SNS is so intent on the revisionist notion of that legacy of the state. And then with regard to nationalism, I mean that's a huge.
It's just a cocktail question.
No, I mean it's a good question, but I think particularly, are you? Yeah, my notes.
Yes.
Okay, nice to meet you. So I think in particular with Croatia and Slovakia, those are countries that felt like they've been oppressed within federations. So like the Slovaks felt oppressed by the Czechs and by Prague, and I think that the Croatians felt like they were dominated by the Serbs. And had only these small periods, or this one small period where they were independent, and then where the Slovaks at least felt also oppressed by the Soviet influence, and so they were sort of, in a sense, they felt colonized too, and so I think that intensifies that sort of reassertion of their own national sovereignty, but it's not, of course, nationalism isn't exclusive to those cases, but it's a really important question.
We are way beyond our time. Let me maybe just, it maybe is an unnecessary reminder, but it is maybe helpful and important to remind ourselves that the countries we are talking about are countries that have gone through a truly torturous history throughout the 20th century. 2 world wars were mostly carried out on their territory. They've suffered imperial domination, also during times of growing nationalism, not just in Eastern Europe, but East Central Europe, but in other parts of Europe. It has been a tortured history, and this history has come to an end 25, 26 years ago, and we are now trying to process the progress that has or has not been made since then. Maybe the hint at successful election systems and regime transitions is one that feeds again into some element of optimism we might carry away, even though we know that a healthy democracy cannot rest on functioning elections alone. But these are some unqualified comments which should not take away from the profound insights we gained from our 3 presenters on this panel. I thank them very, very much, and thank you for participating.